Good evening. My name is Joe Sam Robinson. It's my pleasure to have with us tonight Mr. Harry Gross, who is Chief of Research at the Georgia Neurosurgical Institute, and I might say a rather dedicated Democrat as these things go. I'm sure he's open to other opinions, but he's in that sphere of the world. And we've had several discussions about the tariffs, which are this extraordinary world event that's taking place. And I think in the past we've been fairly critical of the tariffs, and I will make an effort to think of whatever I can that would support their presence. It's a little difficult, but tariffs have been around for a long time. Apparently, we've gone through a period where tariffs were fairly high around the world. Things have gone up and down, and then the U.S. reduced their tariffs substantially. I think that's and this has been going on for a long time, and other countries may not have. So there was a certain imbalance with the tariffs. Whether or not that's the case is another matter, but one could say that I think of some positive things. Maybe there would be some additional revenue raised for the government. Maybe it would encourage manufacturing or industry to be in the U.S. Maybe it would chastise overweening other countries. Maybe they'd be chastised by that. Maybe the U.S. power would be increased. Maybe there would be more jobs, maybe. Well, that's about what I can come up with. Now, I would have to say that these facts should be stated. However, assessing it, they're somewhat shaky. But now we can get into this issue, which I think is a big one, and that is the ability of the president to propagate these tariffs. And I think you're ready to discuss that. Is that correct?
I am, yes.
So this, by the way, this is a huge thing. It is a huge. So the president has assumed what amounts to war-making power. War-making power. This is essentially declaring war on the other 95% of the world's population. I'll say that. It's a huge, extraordinary event of presidential power assertion. But now
I would actually argue it's greater than war-making power because the War Powers Act requires congressional notification and congressional approval. The IEEPA, the International Emergency Economic Powers Act of 1977, which is what the basis for most of these tariffs are, does not require any congressional oversight or approval whatsoever. All it requires is the declaration of a national emergency. And it does not specify what a national emergency is.
Or who should declare it?
Well, the president can declare a national emergency.
So can Congress? Can anyone else?
Congress could declare a national emergency, but the president is the one in this particular piece of legislation who is empowered to the declaration of a national emergency.
He can do that.
Yes.
So he has, there's no limit to exercising the power of a national emergency. It has to be propagated. All right.
Yeah, Congress has to be notified of it, but they don't have to approve of it.
Right.
And so it gives a wide range of powers. In many ways, the legal options available to the president through this act are pretty broad. It does not, however, and has never been used for tariffs before. It does not specify anything about tariffs, and it's usually fairly broad array of economic options given to the president. The reference that the Trump administration is running with is the ability granted to regulate imports effectively, to prohibit or diminish imports of foreign countries that are responsible for a national emergency.
Now, on that point, Harry, I'll say this. It kind of reminds me of the Reichstag fire. Is there a limit if a national emergency is declared? This is sort of an arcane, law that was passed in 1962 near the Cuban Missile Crisis in the middle of what caused Congress to pass this, and
So-
could the Bill of Rights be abridged? in
So
a
this
national
this
emergency?
law in and of itself was passed in 1977, actually as a way of limiting presidential power, because prior to that, the president had much broader arrays of economic power, and Nixon had been accused of abusing the Trading with the Enemy Act throughout the 60s, and so this was actually an attempt to rein in, because you could only do these things if you declared a national emergency, with the idea that declaring a national emergency means we've got a crisis on our hands. They were thinking in 1977, right, oil crisis, right, with the aftermath of OPEC in '73, maybe a communist invasion, that kind of thing. They weren't thinking the drug trade.
Had there been the use, the Reichstag fire I bring up, but it's a little spooky that this extraordinary aggregation of powers can take place just on the whim of the president. Mm-hmm. He could say, it's a national emergency. You could say whatever, like name anything. I don't know, mad cow disease, whatever, or anything. Forest fires, the danger of forest fires. And it could, and there's no way to define it other than the president's will.
Effectively, the way the law is currently written, and the way that the Supreme Court has exercised jurisprudence around this is largely keeping hands off. That most appeals courts and the Supreme Court have effectively decided that anything that's within the formal discretion of the president is outside of judicial review. And cannot be reviewed by the courts.
Is that right? So
that's the current doctrine.
All right. Part. So allegedly in 1977, the power was restricted, and it was broader before then.
Mm-hmm. It was. Before, the president could do all sorts of things unilaterally, not necessarily imposing tariffs, but a broad range of economic options. The main thing that was being thought of at this point, what this law is most commonly used for, is sanctions. And that's kind of what the goal was, but it was also flexibility in the aftermath of the oil crisis in '73.
Has it been used since 1977?
It's been used a few times. I think
by presidents of different political
political parties, mostly to use for sanctions. It's been used to declare sanctions, I believe, on Saddam Hussein. It was used to declare sanctions on Russia. It has been used all sorts of times for largely dealing with malicious foreign actors.
Well, it's sort of economic power,
yes.
The exercise in U.S. power. Has it ever been overturned?
No.
Has the courts has it ever been gone?
The courts have really not reviewed this. There's a lot of presidential power that the Trump administration is citing as in addition to IEPA that has never actually been used before in American history. Different sections have never been used as official justifications. Despite being part of U.S. trade law, particularly the Trade Act of 1974, there are a few sections that are being referenced. And so there's no jurisprudence. We are in, terra incognita in terms of the law in some of these places.
And so it's been used before in a limited fashion.
Yes.
Was there any, did people bring it before the courts and say this is wrong to put the sanctions on, I don't know, East Germany?
Yes, and that stuff has been brought before the courts, but it usually has not made it out of the Court of Appeals because it's deemed to be an act of presidential discretion and therefore not a misconstruction of the law. That's the only thing that that's the part that's reviewable by the judiciary. It's effectively, did the president misconstrue the law itself in his usage? Not necessarily whether he exceeded his mandate, not necessarily whether this is a good idea or a bad idea. It's, did he fundamentally misconstrue the nature of this law?
Now, one of the things about this is this is the law, but we have the Constitution.
Yes.
And so the tariffs are specifically in
yes.
the purview of Congress.
Article 1, Section 8.
And so, okay, you're going to put sanctions. You can do other things with using this law as long as you don't move into tariffs. Is that fair?
There are a few areas where the president can impose tariffs. Now, they're required by law. That's the difference. Is they are part of laws passed by Congress. So, for example, this is where I've got my long list of cases here.
Law school awaits, Harry.
Yeah, Marshall, Field & Co. versus Clark, 1892, gave the president the ability to suspend duty-free status on certain goods imported from countries who imposed tariffs on U.S. products which he, i.e. the president, determines to be reciprocally unequal or unreasonable.
Is that the word reciprocal? Is that how that
Yes,
entered
that
into
is how
this?
they are phrasing
In other
it.
words, the word reciprocal
Yes.
makes reference to this 1892
Yes, in
legislation.
part, yes. Then you have J.W. Hampton Jr. and Co. versus the United States. The Tariff Act of 1922 required the president to adjust tariff rates in order to equalize differences in cost of production between similar goods. Now, that law's old, but effectively it actually required the president to impose tariffs or lower tariffs to effectively create a balance of power in economic production. If Vietnam could produce a T-shirt for 50 cents and the U.S. could produce a T-shirt for $1.50, then the president was required to impose a $1 tariff to make sure those costs were equal.
Well,
Does that make sense?
is it legal for one Congress to, and a number of them, whatever, I don't know what we're up to, 127 or whatever we're up to, but Congress, but one Congress, Congress has the power to do this, and one Congress says, well, we're going to ignore the mandates of the Constitution. We've decided to give the power to the president.
Yes, we're going to delegate certain acts. Yes,
Can,
and that's
can
what
you
these,
do that?
That's what these cases have been reviewing. Yes, and approving. The most recent major bill that Congress passed that does this delegation is the Trade Act of 1974, and that's the big one that's being cited by the Trump administration. And so there are a number of things the president can do within there.
74 Trade Act. What was the world where the Cold War was underway?
Yes.
And whatever I'm trying. Well, we're getting communist infiltration in the south of us. I mean, so presumably this would be a quiver in our arrow there.
Yes, it was an element of economic warfare in many ways, because a lot of the sections, particularly the ones being referenced now, are designed to be used as cudgels effectively against their country. So, for example, Section 201 gives the president the ability to impose tariffs on goods determined by the U.S. International Trade Commission to pose a threat to domestic industry. Right? That's a key part of that. The U.S. International Trade Commission, a federal agency, has to determine a good is a threat to domestic production. Like if China is producing, I don't know, let's do with the t-shirt analogy. If China's producing t-shirts really cheaply and it's going to destroy the U.S. t-shirt industry,
yes,
then this law gives the president the ability to impose tariffs on Chinese-produced t-shirts in order to protect American industry. Section 301 of the same law gives the U.S. trade representative, not the president, but he's appointed by the president,
yes,
serves the president's will. The USTR can impose tariffs in response to countries violating U.S. rights under international trade agreements or which burden or restrict U.S. commerce in unjustifiable, unreasonable, or discriminatory ways. This section has actually been applied to China a lot. China has been the most recent target.
Has that happened over the? I mean, we've had trade disputes. It's
Yes.
a complicated story as to what's happened, and so presumably a great deal of power has been exercised by the executive branch.
Yes.
In sort of quasi-economic warfare.
Yes.
Based on these laws.
Yes.
Go and say that, and so it's been routine. Did Bill Clinton use these powers, or
Not very much. Obama used them a little bit. Most of the thing is these are kind of last resort pieces. There is another section, I can't remember which one, that gives the president the ability to effectively almost ban imports of certain goods from certain countries that has never been used since it was done, but it's been referenced a lot in trade negotiations.
is it in the legislation?
It's in the legislation, but it's never been actually like used in justification. But it's often used in trade negotiations by saying, "Hey, if you don't want to give us a preferred rate on this, we can walk away."
Has Congress ever turned the president back from exercising power under this legislation?
Not really. With the exception of IEPA, which is intended to try and keep the president from doing certain things outside of major crises. That's usually the Congress has actually trended to give more and more power to the executive through these actions.
Well, that's kind of a big deal, isn't it? I mean, I mentioned the Bill of Rights, so presumably, if this legislation is there, you could use it as a cudgel, as you said, to impose personal liberties or whatever. I don't know. Let's see. I don't know, whatever. Part of my religious arrangements are getting some kind of unusual Buddhist, I guess, equipment from Tibet, so to speak. And I can't, I'm stopping your religious equipment from coming in. I'm interfering with your religious freedom.
Yes.
Is anybody ever go that way? Or
actually, there is a lawsuit underway by the Blackfoot Nation. It's not quite under religious freedom, but they're arguing that tariffs on Canada, because the Blackfoot Nation extends across the U.S. border into Canada, that it's a violation of tribal treaties.
Yes.
And that they're in it by imposing tariffs on Canadian goods, even though it would technically be within, because they have to cross the U.S. border to get to the American Blackfoot tribe, is a violation of existing law. So that's one approach that is being taken in a similar vein. No one's quite gone after the religious liberty argument.
In other words, what I'm saying is that exercise of power, whatever it is, if you're aggressive enough in exercising power, you're going to bump into some restriction on the use of power embedded in the Constitution. So the idea is, the state is not a hegemon. It has limits to what it can do and not do, and that's certainly possible to look at it that way. Right now, you mentioned that suit. I understand there are a number of suits underway right now, and this has there ever been such a powerful use of this legislation? And
no. This level of moving very, very quickly and very, very extremely has never been seen before. This legislation has been used in isolated pieces, right? We'll impose tariffs on one country at a time, or we'll use it to. Well, it's never actually been used to impose tariffs before. But we'll use it to impose sanctions, right, on one country at a time, or something like that. We've never been used IEPA to impose tariffs, so that's already uncharted territory. And two, we've never imposed this many tariffs on this many countries, certainly not universally, under presidential decree. Congress has done that several times.
Now, if Congress presumably could say, all right, we're stopping this, and we're passing a law to stop this, and if the president wished, he could veto it.
Yes.
So it would require 2/3 of Congress to basically stop this particular policy.
Yes. So there actually is a bill right now in the Senate, authored by Chuck Grassley, a major Republican. But the White House has already said they're going to veto it, and many Senate Republicans have already said they're not going to get on board, and there are not the votes to pass this bill right now.
So it appears, more or less, that this extraordinary event is at the whim of the president.
Yes.
And so presumably, if this path is there, a president could do almost anything. So this legislation was tossed in there almost at a random event, not imagining that it would be used so extensively as it is now. Now, it's almost an argument for legislation sunsetting. Is there any kind of sunsetting ability? If you pass something, I don't know, the president, or you're entitled to, I don't know what, do something like make sure that animals are safe, something like that. And then for that reason, we're going to come into your house with guns and check and make sure your animals are safe. And is this legislation running into other protective legalities that would prevent the armed people coming into your house to check on the health of your pets, so to speak? Is there other ways that the courts can stop this? And presumably they could. Somebody, am I right on this? Somebody is going to say, if there are 100 suits out there somewhere in different places, someone is going to say this is not legal. And the reason they would say that is it's not an emergency, or the courts are saying that we're using the word emergency. And does the legislation say the whole definition of an emergency is in the hands of the president, not the commonly understood meaning of the word?
So IEPA does not define an emergency at all. It doesn't say that it's whatever the president decided it is. It doesn't say it's whatever Congress decides it is. There is no definition for it, so it's incredibly vague. The main kind of issues that it's going to run into, that these tariffs will run into legally, I think many of these tariffs are going to be found to be legal under various laws. The real issues of where it could be deemed illegal is one, whether through the use of tariffs under IEEPA, because that's never been done before, it's not mentioned in the legislation, whether Trump has fundamentally misconstrued the law. That is one area that judicial review fully applies to and has been used repeatedly on over the centuries. That's one area where you could say you've misconstrued the text, it's outside the bounds, you can't use tariffs. Particularly after Loper-Bright and the removal of Chevron deference by the Supreme Court last year.
Discuss that. What's that?
Yeah, so the Chevron doctrine was added in the 80s, maybe late 70s, but it effectively said that the court should defer to federal agencies' expertise in certain matters, right? That if, for example, if the EPA says that carbon monoxide is a toxin, right, and I don't know, let's say I'm suing the EPA and I say it's not, and it's perfectly safe. The Chevron doctrine said that the EPA should be given extra weight because they're the expertise.
Of course, it's not an absolute prohibition against checking that.
Exactly, checking that. It's just saying that basically
judicial check on that. There's no
prohibition. It's been used to expand the federal civil service a lot, but it's effectively been able to say, hey, these are the experts. They know what they're talking about. We have the data for this. That was overturned last year. So the Chevron doctrine is not part of judicial thought anymore, effectively. Loper-Bright said that now laws have to effectively be interpreted fairly literally. Federal agencies' mandates are now limited effectively to whatever Congress said they were. That poses a whole list of problems on its own, which I'll get into. I don't think overturning Chevron was a good idea for good governance.
Yes.
But in this case, it might actually be a good thing because it means that under the current textual reading of these laws, that such a dramatic expansion of IEEPA that's not explicitly stated in the law is probably unconstitutional because of that. Under Chevron doctrine, there might have been some leeway to that, but there's probably a bit more weight on that. Additionally, many of the other laws that are being cited, various parts of the Trade Act, require U.S. agencies to actually do fact-finding and not establishing arbitrary numbers. Some of these goods are definitely going to be legally tariffed. Steel is one that there's a long series of legal court cases that say you can tariff steel if it's deemed vital to national security anyway. That can be tariffed. There's a lot of things that we could probably do. The tariffs on China will probably stand.
And the courts are reluctant to interfere with the executive power. That's the way the deal works.
Particularly when it comes to foreign affairs.
They're there to interpret arrangements, and if they were excessive, they would basically make executive opinions impossible. And the power of the executive is what does things. If you're a federal district court person and judge, shall I say, and what do you really know about the Formosa Strait or whatever? I mean, what do you really know about that, or what how difficult it is to get a paratrooper division from one place to another, and what does that do, and all this complexities about exercise of national power. Well, if the courts presumably, with all these cases out there, is a district judge going to issue an injunction? And can that injunction be issued on the basis of one particular, there are several laws that support this. He said, well, this law, the one that you cited, doesn't apply, and so you have to desist. On the other hand, the executive branch could come up with another argument to say, well, that's that law, but I'm now doing this one, and I'm basing my activity on another law, one of the many. Could the judge, I mean, what would happen then? Well, let's go to court again.
That's exactly what happened with student loan forgiveness with the Biden administration. The Biden administration tried one particular tack. Supreme Court said, nope, can't use that law.
Right.
So they moved to a different law which was much less expansive, but the court said, yeah, you can do this part of it. What will probably happen is, assuming an injunction is declared, which is right now a big if.
Would it be? Is it much of an if? There's so many judges out there.
There's some judges, but this will probably end up, even the one that's the two big cases. One is going straight to the Court of International Trade. One is going straight to federal court. The one in federal court will probably end up being moved over to the Court of International Trade.
Can you say what that is? What is the Court of International Trade?
So the Court of International Trade is the federal court set up in the Constitution. I think it's in Article 3. Yes,
really?
I think it's in Article 3. That is designed to regulate commerce.
Really?
Because there's so many questions of jurisdiction, that it's the federal court specifically dedicated to trade disputes. And most of what it does is deal with foreign trade at that point. Yes. And so it will probably be deemed to be in its jurisdiction at that point. And the CIT is much less likely to impose an immediate injunction than a federal district court would be.
But they could.
In
other words, okay, so if you wanted to stop this, why would you pick that particular venue?
Because you're more likely to get standing and not have your suit thrown out pretty quickly. So you're more likely to actually get your case heard.
But there must be, I think, people judge shop, don't they? I mean, and in a political world we're in, people could say, well, here's a judge in somewhere, Long Island.
And the point of the CIT is to avoid that, because the issue with judge shopping, right, is, let's say you're a Florida company and you're being hit really hard with these tariffs and you want to sue, and let's say you're more of the liberal leaning persuasion, you want to get your court in, you want to get a judge in California to hear your case. You don't want the Fifth Circuit in Texas hearing your case.
Yes.
You don't have standing in California because you're a Florida-based company. And so your case is going to get thrown out pretty quickly. The advantage of the Court of International Trade is no matter where you are.
Is it a state issue? In other words,
it's a jurisdictional issue. Yeah.
Is it by judicial districts, or
in
is it
part,
by just the state you're in?
It's by judicial district in that sense. I think the minutia of this is not something I'm an expert in. Of course. But I think that it makes it a much harder to judge shop in some of the interstate commerce clause areas, because of standing. Court of International Trade, you would have standing as a citizen of the United States.
So anybody can get there.
It's much easier to do that, yes.
Would that court issue an injunction?
It probably will not.
Has it ever done one? I mean, it should be fairly. It seems like they would not routinely do it.
Yeah, they don't routinely do that. Part of the issue is, in this case, it actually would be fairly easy to issue an injunction because it's not an issue of like federal law, for example. It's not like Congress passed something and then someone says, hey, this is bad, and then you sue Congress. It's the president did something. Okay, let's see. It makes it easier in some ways to issue an injunction.
Right.
The problem is going to be the climb down, and because so many things are tied up with this, because I mean, an injunction would affect the stock market. It's going to affect futures. It's going to affect manufacturing output.
Well, right.
I mean, it has real consequences. That I think there's going to be a lot of thought given to whether an injunction will be done, and that preference will probably be given to stability and predictability.
And so this presumably would be appealed.
Yes.
This would be appealed, and it would take. Would the injunction persist during the appeal process?
It would persist during the appeal, but
until it was determined that was not legal.
Yes, and then you still have the case to go through. The downside of the courts, I mean, the real downside of using the courts is this path, which unfortunately right now is the only seemingly viable path, given that there are not the votes in Congress to overcome a presidential veto, and Trump is not going to change his mind, I don't think, unilaterally. Courts are going to take a long time. It could be a year or two before we have a real verdict in some of these cases, because they're going to be delaying, they're going to be stalling, they're going to be appealing. It seems to me
you could shotgun it. I mean, in other words, there's 500 or 600 judicial districts, and you could certainly find a judge. Well, we have to sort of wind this up, Harry, and it's been quite insightful review of the situation. So to summarize, do you think, let's say, in acute fashion, let's say the next month, somewhere an injunction would be issued to stop this process? Is it going to? Could it happen that rapidly?
It could happen that rapidly. I don't think it will. but it could. But I would be very surprised if it did. Pleasantly surprised, but
so that's a rather
surprised
difficult
nonetheless.
situation. I mean, it really, and I guess the American people do not really understand what's in the presidential toolkit, and they can really do a lot of things which we see happening.
Yes.
Well, thank you so much, Harry. We'll
Thank
talk
you.
some more about this. Thanks,
Always a
thanks
pleasure.
for being here. Yes, thank you.